It's always a pleasure to be on this side of the dais when talking to judges. Occasionally I'm on the other side. I much prefer this side. Thank you, Henry and Paige, for inviting me to do this program. You noted that Henry said that I've been asked to do an overview, and that's why I have a PowerPoint. I don't like PowerPoints, frankly, but it's probably the only way that I'll be able to stay on track and get through this presentation. The presentation is supposed to be at the 30,000-foot viewpoint level because we're going to come back and look more closely at a number of these issues. So let me just begin. This is just kind of an outline of what we're going to do. The second, third, fourth, fifth points are really the subject of the first panel. So I'm going to go through them, but you're going to hear about it more as we go along. The seventh point will be the topic of another panel as well. So we will be going over this ground, and this is more to lay things out. Now, you'll notice the last point I have is corporate criminal liability in other countries, time permitting. And that comparative perspective is probably not of much value unless you're a federal judge and you're looking to what other countries are doing and deciding what the Constitution requires. And Judge O'Scanlan is smiling out there. He knows what the references to, of course. But really, there is a more interesting comparative perspective that I'd like to call your attention to, because at least 75% of you are state judges. And yet, almost this whole presentation is going to be about federal law. So what difference does it make to you? Well, look on it this way. This is a cautionary tale about what could happen in your courts if you're not careful. So, here we go. The history of corporate criminal law, as it says, is long and complex, but it really begins in the Anglo-American countries because the continental countries are much more resistant to it. The current state of U.S. law is far from the traditional view, and by that I mean it gets away from the whole business of act and intent being identified with an individual. The corporation itself today, certainly at the federal level, may be charged with committing a crime, or it may be criminally liable for the acts of officers and employees. In English history, obviously the corporation was recognized as a person, but we know that corporations are abstract persons, and you have limitations in terms of what you can and cannot do with a corporation. In a famous article by John Coffey, he quotes a line from a British judge: "No soul to damn, no body to be kicked." The point was corporations don't have a mens rea. They can't act except through their agents. And how do you imprison them? You really can't do that. And what happened was that the early cases got into corporate criminal liability. It was really 1842 that England did this with statutory offenses and moved from cases like nuisance into nonfeasance and later misfeasance. The American history comes later. It developed more slowly than England, but actually, as time goes on, and make sure I keep flipping this chart, but as time went on, the American pattern, due to federal criminal law, diverged and went beyond the English law. It really grows out of an acceptance at the federal level, much more so than at the state level, of the concept of strict liability. But even originally, or at least for a long time, corporations could not really be guilty of crimes that involved a criminal intent. I think it's important to stop here at this point, especially before I get into the first Supreme Court case, to realize that the development at the federal level is largely tied to the whole business of federalism and the limitations on the federal government in enacting criminal statutes. The import of that for state courts is that state statutes are very differently drafted. Most of the states now have criminal codes, many modeled after the model penal code. By and large, state criminal law is fairly rational. But if you've never ventured into federal criminal law, the only way to think about it is to think about the tax code. It's about as rational as the tax code. And it is so terribly complicated because of constitutional jurisdictional issues related to federalism. And these issues have no bearing on state law at all. So that when there are attempts at the state court level to follow what has been done at the federal level, it doesn't necessarily mean that that makes any sense. One has to figure out, why did the federal case do what it did in the first place? So last year there was an Illinois decision by the Supreme Court here in the case of Forsyth versus Clark, following a U.S. Supreme Court case, U.S. versus Best Foods. This is not on the slide. And the Supreme Court had recognized that there could be criminal liability based on the actions of a subsidiary corporation. Remember that the federal system has no direct authority over corporations. It gets to it indirectly through the Commerce Clause. It gets through SEC regulations regarding public corporations. Corporations are creatures of state law. The states have more options regarding corporations than does the federal government. The general principles as they stand today are that in the federal area, tort law has been largely incorporated into much of criminal law as it affects corporations. So under federal criminal law, corporations can be liable for actions of officers or employees acting within the scope of their employment. And we'll talk about the fact that there has to be an intention to benefit the corporation. This would probably be my one reference to state law, and that's the Model Penal Code. And the Model Penal Code is different from the federal viewpoint on corporate criminal liability. There are three basic sections, and I've summarized them here. First, if the offense language itself authorizes it. That's often not an issue at the federal level. That is, the federal courts often simply look to the term person and say person is sufficient. We don't have to find particular language in the statute affecting or identifying corporations. Two, if the offense consists of an omission or discharge to discharge a specific duty, a duty directed at corporations. Three, this is the one that comes closest, but you'll see the limitation. If the offense authorized, etc., is by the board of directors or, quote, high managerial agents acting on behalf of the corporation within the scope of the office or employment. A number of the doctrines that we're going to see in federal criminal law are totally detached from that. They're in no way limited. And so many of these doctrines simply would have no place in state criminal law. But what we're going to find is that as these doctrines have developed, federal courts have gotten more and more away from the requirement of a mens rea and have been more accepting of the concept of strict liability. The original case in the federal courts dealing with corporate criminal liability is New York Central and Hudson Railway. This case in 1909 dealt with the Elkins Act, a regulation of railroads. And the act itself specified any agent. So Congress had specifically targeted this statute towards corporations. It was not a case where the courts were making it up. The Supreme Court held that Congress has the constitutional authority to subject a corporation to criminal liability for the actions of its agents. That's the critical point. What the court was saying was that Congress could do that under the Commerce Clause if it so chose. And it justified this, that is, the court did, and obviously Congress did, on policy grounds that otherwise the Congress has no effective way actually to regulate corporations. Now, I could debate that, and I won't debate it here, but realize that Congress's power here is the power to regulate commerce among the states. And what it starts out as is a minor punishment that is attached to essentially regulatory law. In other words, these are not true crimes in the common law sense at all. They are regulations that have attached to them initially a minor criminal penalty. The doctrine of respondeat superior, which we're all familiar with from tort law, is primarily the doctrine relied upon to extend corporate criminal liability because agents are treated as they would be in a tort context. Their actions are attributed to the corporation, and so we get this expansion at the federal level, and one of the cases is United States versus Hilton Hotels. And much of the law in this area is developed not by the U.S. Supreme Court, but by the courts of appeals. This case was a Sherman Act case, an antitrust case, and it involved a boycott by an employee of, it involved a boycott by certain hotels of certain suppliers. In this case, the corporation was held liable, but it was liable even though the conduct was expressly prohibited by corporate policy. Now you may say, well, of course corporations are going to prohibit the policy and then they're going to have a wink and a nod, and then employees down the line will violate the policy knowing that they are in no way going to be punished for this. But in this particular case, it was not only general corporate policy. The particular employee had been admonished by his supervisor not to do it, and the employee admitted that he did so not really even for the benefit of the corporation, but he happened to be upset with a particular supplier. The Hilton case, however, wasn't paying attention so much to the particular facts as it was looking at the general question of whether a corporation ought to be liable even when the employee acts against policy. And the argument is that corporations nevertheless in some way benefit, otherwise the employee wouldn't have done it. The employee is doing so to keep his or her job. Another issue related to this business of respondeat superior has to do with collective knowledge. How do you determine in a corporation, it's admittedly very difficult, which agent, which employee is really responsible for violating the law? It is intended to address largely a corporate problem. And again, I come back to the issue that the federal government can't really reorganize corporations. The state level, there are other sanctions, other laws that can be brought to bear upon corporations. One of the important cases in this area is United States versus Bank of New England. This involved currency transaction reports. You know, when somebody either deposits or withdraws over $10,000, banks are supposed to file what's called a CTR with the federal government so the government can track the movement of large amounts of currency. The statute provided that the mens rea was, quote, willfully fails, quote, as part of a pattern of illegal activity. Now, the court took the position that because in a big corporation, especially a bank, where you're dealing with many transactions like this, it is very difficult to pin down who was in fact responsible. So the case says that acts of the corporation are acts of its employees operating within the scope of their employment, and that you can look at the collective actions of the corporation to decide whether or not there is a pattern. I mentioned earlier that there has to be an intention to benefit the corporation. Not only does the person have to be acting in the scope of his employment, but theoretically at least only if the act is to benefit. In Sun Diamond, which the Supreme Court reversed on other grounds on a separate issue, we're looking at this limitation supposedly, but the limitation is not terribly much a limitation. In this case, you can see its erosion. The agent employee does not have to be acting solely or even predominantly with the intent to benefit the corporation. In this case, the corporation, it was a campaign contribution situation where an employee entered into a conspiracy to help the brother of, at the time, Secretary of Agriculture Mike Espy. And there were illegal contributions gathered. And the employee of Sun Diamond said, don't worry about it. We're going to submit some false bills, and the contributions that you have made will be refunded to you by these false payments. Clearly illegal all the way around, but the corporation itself was defrauded by its employee. Nevertheless, the corporation, under this doctrine, still in some way is said to benefit. Corporate officers, excuse me. We turn then to the doctrine of responsible corporate officer. This is not dealing directly with corporate liability, but rather with the liability of individuals. We have, however, again, the issue of strict liability. Corporate officers are criminally liable for failure to control the misconduct of subordinates or the failure to discover or correct misconduct. Now, there's certain qualifications we're going to see on that, but generally that's the principle. Corporate officers are criminally liable even though they were not personally involved and even if they were unaware of the conduct. What the court has done over the years, beginning in a case in 1943, the Doterite case, has been to say that because of the problems with corporations and the difficulty of pinning responsibility, at least initially in the area of the Food and Drug and Cosmetic Act, the court took the position that we're going to impose a very strong burden on the corporation, a theory of deterrence that if the president or other high officers of the corporation realize that they can be criminally liable, and they are going to take every effort they can to make sure that they're not liable. That's the theory. Now, that notion really was rather limited for a long time, specifically in the food and drug area. And it was a justification because of the problem of what happens, obviously, and we've seen it a couple times in the last few years, where tainted food gets into the food system. People have no way to protect themselves. And obviously, under the Commerce Clause, this is a primary responsibility of the federal government, not one that the states can in any way effectively police. So there's no question of the federal government's responsibility here. The question is this an effective way to do it? Now, in the area of food and drug, I don't think that many people are going to really object to that. And even though it is in a way strict liability, these corporations are on notice of a strong obligation, and it is really imposing a kind of liability based on omission. So although it is strict liability of kind, it is a rather focused one. In more recent years, however, this has been expanded to prosecutions under environmental laws, the Clean Water Act, and others. In this context, however, one begins to wonder, does the same rationale apply? The responsible corporate officer doctrine, which I'm going to talk more about on the panel because I'm beginning to run on time, will address what has happened in the environmental area in the Britton and the McDonald cases. Public welfare offenses, which will be important to the discussion of the later developments in the area of corporate officer, actually predate all of this, and they go back to the first of the corporate, responsible corporate officer cases. That is to say, for many years, and even still, at least I and some others in criminal law, make an important distinction between, quote, true crimes and public welfare offenses. The rationale, as we'll see, for these offenses I've basically just given on food and drug. It's to protect the public welfare. It shifts the risk of dangerous activity to those who are best able to deal with it. And because of the complexity, juries may be ill-suited to figure out who is in fact responsible. And obviously, this is the one that prosecutors always like. It eases the burden on prosecutors. If it were up to prosecutors, and I'm a former prosecutor, You get rid of mens rea altogether because that's the most difficult thing in certain cases to prove. And it certainly does reflect the public's intolerance for certain types of conduct. In the public welfare doctrine, though, in recent years, there has been a tension going on. And on the one hand, we'll look at international minerals, and then we'll look at the Staples case just briefly. Here, in the international minerals case, the court was dealing with a shipment of dangerous chemicals. Now, that comes pretty close to the Food and Drug Administration problem. And the court establishes a strict liability standard. And there's a debate here, and I'm not going to go into all the details. It has to do with the legislative history of what Congress did or didn't intend. And there is a debate, a pretty good but technical debate between the majority and the dissent. The rationale is that the probability of regulation is so great. In other words, how do you tell whether it's a public welfare offense? The argument is that if it's such a dangerous material that you're dealing with, that you must know that it is highly regulated, and therefore, like the food and drug area, the obligation is thrown on you to make sure you're not in violation of federal law. Well, that is in the 1970s, 1971. By 1994, we get Staples versus United States, which is an interesting case, really kind of on the other end of things, in the sense that it deals with registration of a machine gun. And to many people, any kind of automatic weapon, whether semi-automatic or fully automatic, is as dangerous a thing as you can get. And this is reflected very much in the court's opinion. But the court attempts to set out a framework, at least the majority does, on how to deal with or distinguish between a public welfare offense and a regular crime. In other words, they're trying to say, when can you allow strict liability for an offense? The majority goes back to the traditional common law rule that emphasizes mens rea. They emphasize that mens rea has to be the background rule, so that in the absence of a clear statement to the contrary by Congress, the court will assume that even when Congress has not included a mens rea, the court will assume that there should be a mens rea there and will read it in. Public welfare offenses, where they don't read in a mens rea, has to involve such an offense that is inherently dangerous. The court basically split, in this case, where a person had a semi-automatic rifle, which, because it had been modified, became fully automatic. And under federal law, the fully automatic rifle had to be registered. The question was whether this person was so on notice as to know and therefore should be held liable to a strict liability standard, or whether a non-fully automatic rifle is not so inherently dangerous as that the person would not be put on notice. The court split on that, and that in many ways explains the different attitude in the whole area of public welfare offense. How much are we going to push into public welfare offense and relieve prosecutors of the requirement of proof of a mens rea? The Weizenhoff case is an interesting case because although the date is 1993 and I have en banc here, it's a little bit different than normal case because it was decided in 1993, but the Staples case, which I just went over, was decided after it, and the court came back and modified its opinion, didn't actually grant en banc hearing, but there's a dissent from the denial of en banc. And the debate is all about the impact of Staples and what it does or doesn't do to the earlier case, international minerals. It was a violation of the Clean Water Act for discharging pollutants into the ocean. And it shows how you are going to get splits on the federal circuits where different judges are going to take the decision of the Supreme Court and tend in this area to go one way or the other based on whether or not they think the object in question is really inherently dangerous to the point that it puts the user on notice. The court distinguished the Staples case. The dissent, however, went on at length to say that we were moving away from the traditional principle of mens rea, and this was dangerous because although in this case the defendants were really clearly guilty, the principles stated in the three-judge court opinion were such that it could be applied to innocent activity and that all kinds of ordinary citizens were, as a result of this decision, liable criminally for things like skipping a rock on the water. Now that seems extreme, and hopefully prosecutors won't take that kind of view, and that's an important point to make, I think. That is to say that initially, in the public welfare offense area, the court said that they were relying on the common sense of prosecutors and juries not to bring certain cases that shouldn't be brought. And that brings us to the criticisms of the public welfare offense. The real problem here is that Congress often doesn't make itself clear. For one thing, Congress prefers not to make itself clear because then it is more fully accountable for what it does. Moreover, the Justice Department is often involved in drafting federal criminal legislation. It then kicks it to federal judges to interpret ambiguous statutes. And here I think it is important to emphasize that in federal criminal law, there are not, as there is in state criminal law, clear statements of the meaning of mental elements. In the Model Penal Code and in other states that don't follow the Model Penal Code, you have a fairly understandable statement of law, either by statute or by case law, of what the various mental elements are in that jurisdiction. In federal criminal law, because of the complexity of the statute, even a word like knowing creates all kinds of difficulties for courts attempting to determine what the word knowing actually modifies. I know this can also be a problem under the Model Penal Code because you can have the mens rea applying to different elements of the crime. But it is much more complicated in federal criminal law, and words such as willingly, or willfully can have varying meanings in varying contexts. So the question ultimately in federal criminal law is the role of judges versus the role of legislators. To what extent should judges, in fact, be making up for deficiencies in the legislative process? In doing so, we're deciding what criminal behavior is and what isn't. Should that be left up to Congress, not the federal courts? That's really a separation of powers issue, and I know that in some of the states you have different attitudes depending on the background regarding your constitution, your state constitution, and what attitude it takes towards, if any, the remaining common law power of judges in the criminal law context. Where we started was an emphasis on the fact that there tends to be a great deal of tort law, namely through vicarious liability, being brought into the whole area of federal criminal law, certainly as it relates to corporations. It was said by, I think it was John Coffey, that what happened during the 1980s was that there was almost a complete merger where tort law and criminal law at the federal level became largely indistinguishable. We are merging public and private law, and people seem to be forgetting the different purposes, that criminal law is all about vindicating a public wrong, and that even individuals who have been the victim of that public wrong, that their private rights are largely vindicated by tort law. the distinction between public and private law, between tort and crime, represented several centuries ago an advance in criminal law. It seems, however, that in blurring this, we are in many ways doing away with what was once considered an advance. Also, the emphasis on mens rea, certainly considered an advance. In some other countries, mens rea is not nearly as important as it is here. Among the other criticisms are that criminal sanctions ought to be the last resort, and that, of course, as I've said over and over again, this whole movement is contrary to the emphasis on a guilty mind. At the state level, you're beginning to see more, I guess, depending on the state, prosecutions for white-collar crime, local prosecutors wanting in some way to emulate federal prosecutors. But the reality in most states is that local prosecutors are so busy with violent crime, property crime, burglaries, etc., that they don't have the resources to deal with these kinds of issues. And so the focus of state law unavoidably is going to be with those kinds of crimes. But when these kinds of issues related to corporate crime do come up, it will be a matter for state courts, obviously, to deal with it. One of the cases cited in some of the articles about state criminal law is a case from Louisiana, which I've not got here. It's a case involving, case was called Chapman Dodge. And the prosecutor attempted to apply a theft provision to a corporation in rather unusual circumstances. And although the statute in the state literally, that is the definition of a person, literally covered corporations, the state Supreme Court refused to apply it to a corporation, saying it was inconsistent with the basic understanding of mens rea. Now, that notion of interpretation is one that has been coming back somewhat to the Supreme Court. I mentioned it in the Staples case, but some of the other cases that are important here, U.S. versus Gypsum, which was a Sherman Act case, the court resisted the attempt by the Justice Department to take interpretations of the Sherman Act on the civil side. The Sherman Act covers both civil and criminal, and the Justice Department had attempted to move that over into its interpretation on the criminal side, and the court distinguished between what was required to establish a civil violation as opposed to a criminal violation, and it resisted the attempt to ease up on the mental element, saying that to do so would be to impose strict liability. Here the court went back and repeated over and over again the tradition of the common law, citing various cases. One of the most important of these is the Morsetti case. Bryan versus United States, case dealing with firearms without a license, an example here where the court splits on this. So we have this tension in the court, depending on a few votes, as to, in some cases, the court is giving great emphasis to the principles of mens rea in terms of interpretation, and in other cases, not doing so. In particular, some of the federal statutes will say that it is a criminal violation to knowingly violate a certain regulation, and then it delegates to the particular agency the power to create that regulation. The issue for a court often then is whether the word knowing modifies knowing that it is a violation of a regulation, which raises the issue of knowledge of law, or whether ignorance of the law is a defense, or whether you have to actually know only that what you have done is a certain type of action, and that action happens to be in violation of the law. As I say, this is peculiar to federal criminal law. It's not the kind of thing that, as far as I know, is that large of a problem at the state level, because you don't have the whole-scale delegation of power to create regulations to executive agencies certainly not to the extent that you have at the federal level. And in the areas of the environment and the public welfare offenses, we are often dealing with regulatory statutes. And again, these are statutes that have a criminal penalty because Congress has authorized a criminal penalty to be attached to whatever regulation it is that the agency comes up with. Criticisms of merging tort and criminal liability. Largely in the academic area, most of the commentary has been critical. Again, over and over again, the mens rea is even more important today because there are so many crimes that are malum prohibitum. It is difficult for people to know what is in fact a crime. In certain areas that are highly regulated, people are expected to know those regulations because they are trained, certainly if they're in the banking area, certainly if they're in the chemical area, they're given training to know what these regulations are. But the extent of the regulations, the complexity of the regulations make it difficult to give reality, in some cases, to actual knowledge of the law. If traditional requirement of mens rea is weakened, then it undermines unique features of the criminal law. Oftentimes people think, well, you know, we ought to prosecute corporations because, after all, they're doing bad things, and to argue that corporations ought not to be prosecuted is somehow to be light on corporations. I frankly don't care much about defending corporations. More often than not, I'm suing them. But what I'm most concerned about is the erosion of the principle of mens rea as applied to individuals. The reality is that the more that the principle of strict liability is accepted, and this is what historically happened at the federal level. After the Doddridge case, many assumed that the idea of strict liability was equal to mens rea, and it was a choice of the legislature, and courts ought not to favor one over the other. As I've attempted to emphasize, the Supreme Court has, although not always consistently, come back and attempted to emphasize that mens rea is not just another rule. It is the background fundamental rule. At the state level, that is still largely the case, despite the fact that there is recognition in the Model Penal Code of limited use of strict liability. But in our state, for instance, even when statutes don't have a mens rea in it, the courts will routinely read in a mens rea. We've had drug cases where there is no mens rea in the statute, and the court either reads it in, or in one case where the legislature came back and made it clear they didn't want a mens rea in, they said, look, you simply cannot have a prison term of any consequence with no mens rea. It goes back to fault. And that was one of the other points made in the Staples case. The origin of public welfare offenses related to the notion that they were minor, that they had a minor penalty, and that they carried no moral stigma. The fundamental distinction between tort and crime is that crime carries a moral stigma. But we're tending to lose that notion. Well, how did that come about? Well, we all know the term white-collar crime, but many people don't understand where the term originated from. You can trace it to one sociologist named Professor Edwin Sutherland, who coined the term in a 1939 speech and then in his book, 1949, White-Collar Crime. Now, he was at Indiana, and a professor, a famous law professor named Jerome Hall, who originally taught at LSU and then went on to Indiana, he was Sutherland's great critic. Jerome Hall was the great defender of mens rea and argued against its dilution. His criticism of Sutherland was this, that Sutherland's whole understanding of criminal law violated the common law understanding, because Sutherland came along with the notion that corporations and executives are really guilty of all kinds of crimes, but they're not being prosecuted because they're not labeled as crimes. In Sutherland's view, any violation of an offense, any regulatory offense, was a crime. And he thought that corporations and executives should be denied the privilege against self-incrimination, and that they should not be required to have proof beyond a reasonable doubt. In other words, everything we ever teach in criminal law, he simply attacked. It was a fundamental change in our understanding of criminal law, but it was one that was not accepted basically until the 70s with RICO and then the 80s. Why RICO? What's the relationship to RICO? We're talking about corporations. RICO is an expansion from corporate liability to, quote, enterprise liability. And enterprise liability was invented by one of Sutherland's proteges. And again, it was an attempt to expand criminal liability beyond traditional notions. What particular traditional notion? The Supreme Court had, in the famous Lanzetta case, said that you could not punish being a member of a group. You had to have an act. And in an article I've written, I tracked all of this. The whole effort of RICO was to get around that Supreme Court case. How could we effectively criminalize being a member of certain entities? And in fact, even the Justice Department originally didn't know what to make of this. And it was named, of course, by a friend of mine, Professor Blakey at Notre Dame. RICO was a character in a movie from the 1930s that he liked, and so you get this strange name, Racketeering Influence Corrupt Organization Act, so he could end up with RICO. Anyway, so it was passed in 1970 to fight organized crime, and initially, even the Justice Department didn't know what to do with it. But it didn't take long before prosecutors and, more importantly, plaintiffs' attorneys figured out the usefulness of RICO, because in many ways RICO was modeled on the antitrust laws. It had both a civil and a criminal component. But what ultimately happened is that it blurred white-collar crime, organized crime, and under Mr. Chertoff, terrorism. They all became forms of enterprise criminality. In fact, the originator of the enterprise liability concept has a quote that I have in one of my articles saying that the only difference between business executives and corporate and organized crime figures is that organized crime figures don't have good manners, but over time they will develop better manners. I mean, clearly driven both by Sutherland and those behind the academic base for RICO, a very anti-corporate mentality. Again, I'm not particularly defending corporations, but I am defending the traditional common law notion that crime is about moral turpitude and that to have fault in a moral sense requires an act in some kind of mens rea. Well, what have been the trends in prosecutions? As of the early 80s, sociologists were lamenting the fact that the term white-collar crime had not really gotten any traction. Well, since the 80s, much has changed. The savings and loan debacles of the 80s and later have changed much, and the media's stories and all of the fallout from this and the increased attention by Congress under the war on crime has changed attitudes quite a bit since 1980. And when people, certainly by the time of Enron, with many people invested in the stock market, they were paying much more attention to financial crime than they had been some years ago. And so we have seen quite a shift in public attitudes and therefore in terms of attitudes of federal prosecutors and their willingness to go after this kind of crime. I'm going to go briefly and only briefly to the organizational sentencing guidelines and to DOJ charging policies. In our panel, Ms. Alice Fisher is going to spend more time in this, but in an article that was given to you for possible reading, I just want to make a connection here. As I mentioned at the outset, the federal government has limited authority over corporations. But what happened in the 90s was that the Justice Department took new sentencing guidelines that were issued in 1992 by the U.S. Sentencing Commission on organizations. They took that, and you had the beginning of what's called the compliance officer era. There were no compliance officers in 1990, really, except maybe in the defense industry. And all of a sudden, you have an explosion of compliance officers because in order to avoid or diminish sentences for organizations, the notion came about that if corporations instituted compliance programs, that these compliance programs would be taken into account. The Justice Department then came along with a series of memoranda that will be talked about by Alice, and I'll mention here before getting to that, and this is just briefly for those who aren't familiar with it. The Sentencing Commission was controversial constitutionally, as mentioned in the last case, but the Supreme Court upheld its constitutionality. Nevertheless, in 2005, the Supreme Court said that the sentencing guidelines were only advisory. Despite that, the charging policies of the Justice Department, when linked together with the sentencing guidelines, become a hammer to regulate corporations, because the notion is that corporations should be partners with the Justice Department, an interesting kind of partnership. They should be partners in helping to police, interesting concept, that they should turn over voluntarily to the government. This is the background for DOJ charging policies regarding corporations. So that federal criminal law is now more about regulating corporations so they will be, quote, good citizens. Federal regulation has expanded with the expansion of commerce across state lines, again, blurring regulation and criminalization. As I say in the article that I wrote, we are going back to a concept of corporations rejected in the Jacksonian era. Originally, corporations in the United States were highly regulated by government. And the Jeffersonians and the Jacksonians opposed that because they thought that corporations therefore got favors from government. It was in the Jacksonian era that a more laissez-faire attitude towards corporations came about. Moreover, a more egalitarian notion towards corporations came about. So today, as you well know, creating a corporation is not some privilege from the government. You get a corporation by simply filling out some forms and paying a fee. Anybody can create a corporation. We're going through a period, however, in which that dominant notion of corporation is being changed largely under the impetus of federal prosecutorial law. When I get on the panel, or at least in the later panel this afternoon, I'm going to talk more about what has been the effect, if any, on the development of economic issues in the United States. In running on time, organizational sentencing guidelines, as I said, Alice Fisher is going to do this, but basically I've touched on this. Compliance programs are now seen as mandatory. Lawyers who don't advise clients on compliance programs are said to be engaged in malpractice. The standard of what constitutes an effective compliance program, however, is uncertain. Prosecutors, rather than courts, effectively decide what is an acceptable compliance program. And you're not going to find out until after the fact, when it's too late. This all became very controversial, beginning under the Clinton administration with the famous Holder Memo, the same Holder who is now Attorney General Holder. In 1999, the Holder Memo, tying to compliance programs and corporate cooperation, listed factors that federal prosecutors should consider when deciding whether or not to indict corporations. The Bush administration came in actually opposed to the Holder Memo, but As we saw with the Bush administration, many things changed in the first year. You not only had 9/11, you had the collapse of Enron, and all of a sudden the Justice Department policy took a 180-degree turn, and we came out with the Thompson Memo, in which the Bush administration actually expanded on the Holder Memo, and prosecutors now were to consider, inter alia, quote, the corporation's timely and voluntary disclosure of wrongdoing and its willingness to cooperate in the investigation of its agents, including, if necessary, the waiver of corporate attorney-client and work product protections. That created an uproar. As a result of that uproar, Congress was about to act, and as federal agencies are wont, when Congress is about to act, they decide that they will change course somewhat. In 2006, we have a new memo replacing the Thompson Memo, the McNulty Memo. It's clearly a response to the earlier memos and to congressional attempts to do something about it. And now, waiver of attorney-client privilege and work product protections are not necessarily prerequisites to finding that corporations have cooperated. We'll see from the panel and other practitioners to what extent this memo has actually changed anything. I'm not sure. It gives some guidance, at least, to prosecutors where in the past there wasn't, and I think more importantly, puts more control in Maine justice over forcing waivers on corporations in a way that control did not exist before. I've said the last one is time permitting on other countries. Let me just say that, to begin with, that corporate criminal liability is a phenomenon that's growing worldwide. Interestingly, England, which originated this, has not gone as far as the United States, even though England started this in 1842, as I said, and originally followed a respondeat superior approach. It has since modified its approach, and it looks now to whether or not the directors of the corporation, the mind of the directors, whether they had the mens rea. So they attribute a mens rea from the director to the corporation. They're not nearly as expansive as the United States has become. Generally in Europe, there has been a resistance historically to corporate criminal liability. That resistance is changing somewhat. The French were resistant but have opened up some exceptions, and you may have seen a 60 Minutes report some weeks ago that the French are about to try. Continental Airlines has been charged with being responsible for the crash of the Concorde some years ago because it's claimed that a piece fell off of a prior departing Continental Airlines jet that caused the laceration of a tire on the Concorde as it was leaving. So Continental Airlines will be defending that case in France. Germany has administrative criminal sanctions against corporations, but the place really to watch, as in all other matters regulatory in Europe, is really to the European Union. And there we see, especially in the environmental area, an expansion of corporate criminal liability. Beyond that, Japan has recognized corporate criminal liability. But the real, I think, direction has to do with a number of human rights NGOs and others who want to use international human rights tribunals to go after corporations, not merely on environmental crimes, but on such crimes as genocide, where it is said that they have cooperated with certain regimes, and they want to hold corporations liable for crimes basically of murder. That is the direction of corporate criminal liability. As I imagine you have detected, I'm not in favor of it, and I certainly hope that at the state level you do not necessarily emulate the federal example. Thank you very much.